Hi everyone, my name is Costas and welcome back to Legal Talk, where we provide general legal information for the everyday landlord. Today, I want to talk about the Section 78 in the Residential Tenancies Act and the subsequent L4B. I want to explain to you what this section means, how to leverage it when obtaining an order from the tribunal, and how this can benefit you as a landlord. Section 78 of the Residential Tenancies Act states that a landlord may apply to the board without notice for an order to terminate a tenancy or evict a tenant as long as 3 criteria are met. This includes the landlord applied to the board previously requesting termination of the tenancy or eviction of the tenant. The tenant did not meet the conditions imposed in a previous application, giving grounds for termination of the tenant. The tenant did not meet with one or more of the conditions set out in the second point. If these criteria are met, you would file an L4B, which is free to file and wait for a new order to come from the tribunal. When filing the subsequent L4B under this section, it must be submitted within 30 days after the tenant failed to have met the conditions as described. The board may make an order to terminate the tenancy and evict the tenant if they find that the landlord is entitled to an order under this section. Section 77 prior to Section 78 states the times in which it is appropriate to file an application without a notice. Section 77 makes it clear that previous action must have been taken towards the tenant in order to file without a notice. So while Section 77 and 78 are meant for the landlord to file without providing notice, the notice will have been given in advance when you originally took action against the tenant, which effectively counts as giving notice. Let's talk about requesting a provision under Section 78 of the tribunal. If you go into mediation with your tenant and reach an agreement, you can typically request a Section 78 provision quite easily after explaining to the tenant that they must uphold their end of their agreement, or this section can be used. If you go to trial and the adjudicator makes their own determinations for you, you must request this provision, and it is up to the adjudicator if they deem it fair to allow this under the circumstances. In order to file an L4B under a Section 78, it is important to remember that since Section 78 comes into play after some previous application or action has been taken to the board against the tenant, you must have copies of any documents, orders, or decisions made by the tribunal on your case so you can easily demonstrate you meet the requirements to invoke Section 78 if your application becomes contested. This would include affidavits that would verify any agreements or notices of termination previously drafted. Evidence is crucial to invoke this section, so do not misplace or forget the necessary documentation when filing the application. When you filed your L form to evict the tenant the first time, you would have been required to serve an N form prior. And so you do not need to send another notice of eviction or termination, as that would have been covered on the previous application. Provided that you have met the necessary requirements to utilize Section 78, you would be eligible to take action against the tenant without any notice, and the tribunal can order the tenant to pay what they owe you and any arrears to you. It is important to remember, this application must be filed within 30 days of the original termination date from the first application you made. If you allow this time limit to expire, you will be unable to invoke Section 78. Now, can your application be contested? A Section 78 application could be challenged based on the warnings provided in the previous paragraph, such as failing to file an application in the 30-day limit of the original termination date. This type of challenge would be your fault if it applies. Ensure that when attempting to end a lease or terminate a tenancy, that you follow up on all applications or notices as soon as possible to prevent this issue from ever arising. But ultimately, if your L4B under Section 78 is contested, there is a degree of discretion exercised by the tribunal as whether or not another hearing should be held. In our experience, a major fault to this is that if a tenant lies and states your reasoning for your application is under false pretense, it also always leads to another hearing where they would have to prove that your information is incorrect. This is often done as a stall tactic. Okay, so that wraps up our brief overview of Section 78 and filing an L4B. Please remember that this information is meant to provide a general understanding of the various areas under the RTA and filings to the tribunal. It is no way meant to be taken as legal advice. If you have any questions about your specific situation, you must retain professional legal services. Anyway, I hope this has helped you gain a general understanding of how a Section 78 works. If you enjoyed this video, please click on that like button, subscribe to our channel, and visit our website for consultation services if you need any help. See you on the next one.